We're going to go ahead and get started. I recognize many of you are human resource managers and kind of on the front lines of hiring processes. Others are employment in-house counsel and dealing with immigration issues like I-9s and E-Verify. To my left, your right, we have Sarah Belletti. She's an immigration associate who has joined our practice. She's got a wealth of experience, 10 plus years. She had previously worked in Michigan, where she worked on cross-border issues. Those current clients who have been able to work with her. Anyways, hopefully you've enjoyed the experience as I have. So we're going to go ahead and dive in to the H-1Bs themselves. Let's see. So we recognize it may be, many of you may have no sort of immigration basic knowledge, or maybe you're pros at this and you've dealt with H-1Bs on a regular basis. We're going to talk about some things that are new. So that's going to include some more advanced topics like how the H-1B lottery shakes out, including whether or not there's going to be multiple rounds within the lottery selection process. In March of 2022, there were not multiple rounds, but in the prior year, in 2020 and 2021, there were multiple rounds of lottery selection. We'll kind of talk about the implications of that. We will also talk about kind of what are the trends in adjudication right now in terms of requests for evidences, approvals, denials. Right now, at a national level, we are seeing a fairly high rate of approvals due to the Biden administration, so roughly 96% approval rates. In the real world, we're seeing requests for evidences at about maybe 10 to 15% of all submission. We recognize in the post-COVID world, there's a lot of remote work that's occurring. And I think H-1B employers in particular need to be aware of the implications of that. Most specifically, it may trigger updates that you are required to file with the immigration agency or the Department of Labor. So we'll talk about that in greater detail a bit later. We'll also talk about layoffs and reductions of force. Recognize there's a lot of tech companies right now that are going through some challenges. And if you are shedding workers, that does have implications both for H-1B processes and also PERM or green card processes. As part of this H-1B process, there are regular compliance audits and investigations that take place by the U.S. Department of Labor and also the immigration agency. Your government filing fees actually go to pay to fund those investigations. So you want to know what are the potential compliance liabilities that exist and how to address those. And then Sarah is going to talk about also potential filing fee increases, which were just recently announced over the last week or so, and what those may look like. So big picture here, once again, we're talking about H-1B visas, like what does that actually mean in the broader picture? So if you're in HR, you're regularly dealing with the I-9 form, you recognize there's about 3 large tiers of immigration status. So we have at the very top, US citizens. So those are individuals who are born in the United States, or alternatively naturalized in the United States. Then secondarily, we have permanent residents. Those are also known as green card holders. And so to the right here, we have a picture of a permanent resident card that may be a slightly outdated version. So typically those cards are issued for a 10-year period of time. It means that somebody has a permanent right to live and work in the United States. They can work for any employer that they choose to work for. The major distinction between a permanent resident and a U.S. citizen is that a permanent resident does not have a right to vote. They are still typically considered U.S. tax residents and have to pay U.S. taxes. Then at the very bottom tier, we have what are called non-immigrant workers and visitors. So this is the alphabet soup of immigration visas, everything from F1, H-1B, J-1s, TNs. So it's a whole litany of different sorts of typically temporary immigration visas. Each of them come with their own rules. So rules such as what sort of position you can hold, what salary you must be paid, where you can work. And anytime those aspects change, that may require updating the immigration agency. There's a whole variety of documents that are issued for those individuals. They include things such as the document on the left-hand side there. It's called an I-94 Arrival Departure Record. That's issued by U.S. Customs and Border Protection upon entry into the United States. That has actually gone electronic. And so anyways, that is kind of the older version of that. To the right of that is an employment authorization card, also known as a work permit. And so anyways, those can be issued for a couple of years to a variety of individuals. So those are the major tiers. H-1Bs fall within that last tier, of course. And so there's a variety of different temporary worker visas. So these are kind of the tools that you have as an employer in your toolbox to employ a foreign national. When we speak of foreign nationals, often those folks aren't outside the US. They often may be in the US. They may be international student graduates who studied at University of Utah or CU Boulder and just want to stay in the United States. So in the breakdown of kind of the hundreds of thousands of folks who come into the United States, those temporary workers, they can include H-1B workers. So that's a quarter of sort of the non-immigrant visas that are utilized. We'll talk about kind of the conditions associated with the H-1B visa. And then we'll also talk about the L1 intercompany, the L1 intercompany transfer visa that applies to both managers and specialized knowledge workers. It's a fairly specific subset. Those apply to instances where you have a foreign subsidiary or parent company, and you're trying to transfer a worker from that, let's say, subsidiary in India into the United States. We also have E visas and treaty traders and investors. This could be a foreign entity that has made a large, substantial investment in the United States, typically more than $250,000, and they want to bring in essential workers for their processes. H-2B, seasonal non-agricultural workers. These are typically, they could be involved in this landscaping world, in construction, in kind of ski resorts, but typically these are non-bachelor degree workers. H-2Bs are limited to 66,000, which are split between two seasons, a summer and winter season. And then lastly, that 28% in red there, a whole litany of other types of visas, TNs, O1s, J1s, and anyways, we're often regularly on the front lines of chatting with HR departments regarding kind of whether or not those are viable for their specific employees. We're obviously always happy to make a judgment call as to kind of what are the best immigration options based on a resume and job description if you ever want to reach out. So the reason why we're talking about H-1Bs is because that is going to be the best tool for 80–90% of the workers that you are coming across. So the advantages of this are, number one, H-1Bs can be used for any country of origin. So it's not limited to any specific country. There's no per country limits. So for instance, if China or India wanted to use all of the H-1B visas that were available, they technically could. It's also, it's synonymous, or it can work towards obtaining a green card or permanent residency. It allows for what's called dual intent. And so that allows a pathway towards permanent residency or green card. The H-1B visa itself is issued for a 3-year period initially, and then for 6 years total. So it can be extended beyond 6 total years in certain instances where a permanent residency process or green card process has been initiated on a timely basis. The other helpful thing about H-1B visas is that applies to broadly any industry, although the tech industry seems to kind of disproportionately use H-1Bs, and it can be used on a variety of different occupations. So this includes, and is not limited to, everything from software engineers, user design research, data analytics, finance, accounting, legal, marketing, business intelligence. So a wide variety of positions. The two areas that we've seen kind of perhaps a bit of pushback are on sales roles and general managerial roles. So the primary question is whether or not the position requires a bachelor's degree, typically in a specific major or a cluster of majors. This H-1B visa is also relatively fast processing. Premium processing, which is basically an additional $2,500 fee, allows an expedited processing of 15 calendar days. Typically, it takes our team anywhere from, let's say, 3 to 5 weeks to prepare the H-1B petition on top of the 15 calendar days for the government to make a decision.
Looks like we have a question.
Yes, and let's see. So let's see, we have a question from the audience, and I will just mention, and I should have mentioned it earlier, on to the right of the presentation box, anyways, you'll find a chat box, and certainly at any point you can ask your questions through there. We don't have the opportunity to kind of ask questions through phone or by audio, so please go ahead and type your questions in by chat. We love questions because it makes this much more interesting. Sarah, I don't know if you want to take this on or.
Sure, I can. So the question from Lillian is, what about teachers or faculty? And I think this may be related to university faculty. So the answer is, for a teacher or a university professor, an H-1B petition could definitely be an option. It would depend a little bit on the specifics of the position, but essentially, as long as a bachelor's degree at a minimum is required to perform the role in, a small number of fields, and the potential applicant or H-1B visa holder has a degree in a related field, it could absolutely be an option. The other, kind of advantage for the university setting in particular is that if it's a publicly funded university, it may be that the employer could seek CAP exemption. And that sort of will transition well into my next slide about the cons of H-1Bs. And why I say CAP exemption could be useful is because every year the US government gives out only a limited number of H-1B visas. It's capped by statute. So it's 65 total per year, and there's another 20,000 that are allocated to individuals with a US master's degree. So if you have an employer who is CAP exempt, falls within one of those categories, they can seek an H-1B for a qualified individual without regard to the CAP. So that's a huge benefit. For a private K-12 school, I see the follow-up. It's likely that employer would be subject to the CAP. And if they're entering an individual in the H-1B CAP lottery, that person did in order for the employer to file an H-1B on behalf of that individual. But a teacher can absolutely qualify as long as a bachelor's degree at a minimum is required to perform the role. Related to the H-1B CAP, in the last few years, we have seen huge increases in the number of applicants for the limited H-1B visas that are available. In 2022, for example, for 85,000 total visas, there were over 480,000 H-1B CAP registrations. So what that looks like from a kind of statistics perspective is, if you have a bachelor's degree only, the applicant, there was about a 15% chance of selection, whereas for individuals who had US master's degrees or higher in the CAP, they had about a 20% chance of selection. We're not sure what the registration rates will look like for 2023. They could go down slightly, as we've seen some layoffs and some reduction in force in the US job market. But I would anticipate that it will still be much higher than the total 85,000 H-1B visas that are available.
And for those who are who really kind of like to pick apart these numbers, I just want to mention, have some stats here. So 31% of all submissions were kind of the US master's degree category. So that gives you some context for how many folks are actually filing the US master's degree CAP, that 20,000 set aside. About 2 years ago, the immigration agency reordered how they were doing these selections to give more favorable results for basically these advanced degree professionals, these master's degree individuals. And so anyways, that has kind of shown itself true. The other thing I want to mention, 85,000 spots. What's really fascinating about this is that USCIS has to make a decision as to how many total registrations it will accept, knowing that some of these folks, some of these employers and immigrants will not proceed forward with filing an H-1B petition, which is kind of the second part of this, which we'll kind of get further into it. In short, they, like last year, March of 2022, they actually accepted 127,000 registrants, knowing that roughly 40,000 would not move forward with the full registration process, or I'm sorry, full petition filing process. So turning back to Sarah.
Sorry, we advanced one too far. Okay, so what does the H-1B CAP registration process look like more specifically? In 2020, United States Citizenship and Immigration Services changed how the system operates. Prior to that, any employer who wanted to petition for an H-1B visa for an employee had to have the full petition prepared and submitted on April 1st. And then within the next month or so, USCIS would conduct a lottery, and whichever of those petitions were selected would be retained by United States Citizenship and Immigration Services, and any petitions that were not selected would be rejected and returned to the employer. So that basically created quite a hectic life for immigration attorneys, because we had to fully prepare all H-1B CAP petitions and be ready to submit them on April 1st. Otherwise, the deadline would be missed. And, assuming that there were over 85,000 applicants, which there historically have been, you would lose the opportunity to submit an H-1B CAP until the next year. In 2020, United States Citizenship and Immigration Services changed this system, and they've now made the initial step in electronic registration. That registration period typically is conducted for the first 18 to 20 days of March. We anticipate this year will probably be March 1st to March 17th. So in that period, any employer who wants an H-1B visa for an employee has to submit an electronic registration through the government's online web portal at uscis.gov. If they're represented by counsel, there's some back and forth that happens. Like for us, typically we prepare the registration for the client, and then the HR partner has to log in to basically confirm our representation, and then we're able to submit those registrations on behalf of our clients. For HR individuals or in-house counsel that may be or have submitted H-1B registrations individually themselves, that's also something that's possible. You can certainly do it without the assistance of counsel, and then you would do it through that same portal, the uscis.gov. Once the registration period closes around March 17th, USCIS then typically conducts the lottery around March 31st and starts announcing which registrations were selected through that online portal around April 1st. In previous years, as Roger mentioned, 2020 and 2021, there were multiple rounds of the registration lottery that were conducted. However, last year in 2022, no additional rounds were conducted. It was just the one. And it may be because USCIS has kind of honed in on selecting more than the 85,000 total, with the knowledge that a percentage of those cases will not be filed by the petitioner.
Absolutely. We've got a couple of questions regarding the presentation itself. So the PowerPoint presentation will be sent following today's presentation by email. There will also be, anyways, this will be recorded and shared on YouTube in case any of you want to watch it at that point. We'll also be repeating this presentation on February 2nd in case you have any colleagues that weren't able to join and are interested in joining. So.
Great, thank you. Okay, so for the electronic registration itself, what is now required of the employer and the potential H-1B employee is much more minimal than when we had to file a full petition on April 1st. Essentially, the information that is collected to complete the registration from the employer is pretty basic: the full legal name of the company, their FEIN, the primary office location, and the name, title, and contact information for the signatory, which is typically the HR partner of the particular client. From the potential H-1B employee, we need the full legal name, the person's gender, their highest degree attained, their date of birth, and their country of birth and citizenship, as well as their passport number. In order to submit the registration online within the registration period from March 1st to about March 17th, there's no filing of a labor condition application that's required to accomplish that. If the person is selected in the H-1B CAP registration lottery, once we know that that selection has occurred, it's at that point that we would then file a labor condition application for them that would have to be inserted with their full H-1B petition. Important kind of facet of this new registration process is employers cannot submit more than one registration per foreign national employee. However, if the corporate entity has multiple related companies, they could submit multiple registrations for an employee from each of those different companies, but this individual would have to have a bona fide job offer and position with each of those petitioning entities that was submitting a registration. Because USCIS does monitor the registrations that are selected to make sure that petitions are being filed if someone is selected in the registration. And the point of that is to try and avoid abuse. In the first year or two of the registration process, for example, some of the largest US-based tech companies were submitting multiple registrations for each employee based on each of their corporate entities. And I think USCIS is watching that to make sure that there aren't abuses of the system. If a employee is selected in the H-1B cap lottery, you have then 90 days to file the initial H-1B petition. So that's usually from April 1st to June 30th. So for selections in the initial cap lottery round, usually the filing deadline for that H-1B petition is June 30th. USCIS will create a waiting list and conduct additional rounds of the lottery if they don't fill the full 85,000 total quota in the first round. But those later rounds usually are conducted sometimes in July or August, or even in as late as November. In 2021, the third round was conducted in November. But the chance of selection in those additional rounds becomes much, much lower, like less than 1%, I would say.
Yeah, if you're really not selected within that first round, notified by March 31st, it's pretty unlikely that you will be selected in those subsequent rounds. Sarah's done a nice job of summarizing kind of this part one of sort of this H-1B process, which is that electronic registration, obviously kind of that brand new process as of 2020. You can go through this as an employer by yourself. You're not required to have an attorney as part of that preparation process. It only costs $10. There are some potential pitfalls that I guess I would forewarn you about. So you really only have a limited time from March 1 to March 17 to do this. If you put in duplicate entries, all of your entries will be deleted. If you don't have the right information, this will not go through and you will basically lose your opportunity to file. The immigration agency is regularly looking at employers who file these registrations and do not end up filing the part two, basically the I-129 petition for fraud and abuse. So certainly if you end up filing for the registration but don't proceed forward with the filing the I-129 petition, you will have to provide a rational reason for why that did not take place. The other thing I'd mention, within that registration process, you're going to make a selection as to whether or not this is a master's degree cap or a bachelor's degree cap. Note that that master's degree cap refers to only individuals, immigrant employees, who have attained a U.S. university master's degree. Does not apply to foreign degrees or foreign equivalent degrees, does not apply to those folks. The other thing I'll mention is that you have the opportunity when you sign into MyUSCIS to register as both either, I believe it's like a participant or applicant or registrant. And anyways, in order to actually go through the H-1B registration process, you have to select registrant. So that's certainly something to be wary of. Within our process, I want to kind of talk through how we prepare our cases. We recognize for employers, a lot of these immigrant employees are not just some faceless number, but obviously highly critical to your company. And so we want to make sure that we're handling it with care. So bottom line, we have two options, and the major difference here is kind of like when you want to pay the fees and basically kind of whether or not you want to pay more fees or less fees. We have something called priority preparation and then regular preparation. So priority preparation is probably going to be in the minority of instances. Most of you probably will not need that. The ones that will need it are immigrant employees who have an OPT or work permit that expires in April or May timeframe. There's a specific rule that allows them to continue work authorization if an I-129 petition has been filed prior to the expiration of their work permit. And so those are the folks who are going to need that priority preparation. Otherwise, it will be regular preparation, which basically means the Holland Hart legal team will not begin preparing the I-129 petition until after the H-1B lottery registration results have been announced March 31. So our team, just for the sake of transparency, we're charging $1,500 to assist employers within that lottery registration process. It would be $3,000 additional if you're actually selected within the lottery and we move forward with I-129 petition process. If you're not selected within the lottery, anyways, only $1,500 would have been lost. There are some government filing fees that are associated with these cases. It's for most employers, it's going to be $2,460. There's an optional premium processing that is typically available as well if you want a decision within 15 calendar days. All of this sort of priority preparation versus regular preparation, or even premium processing versus non-premium processing, none of these changes your odds within that H-1B lottery. Your odds still remain about that 15-20% rate. So I think for most employer clients, anyways, the regular preparation is going to make sense. In a couple of instances, priority preparation will make sense and will be essential for those individuals who have work authorization expiring in that April-May timeframe. Is there anything you want to add there?
Yes, just one thing. So regarding the current filing fees that Roger just mentioned, the standard I-129 H-1B filing fees at the moment, as he said, are $2,460 with an optional $2,500 for premium processing for some action by United States Citizenship and Immigration Services within 15 calendar days. At the beginning of this year, on January 4th, USCIS published a proposed rule to increase the filing fees across many categories, and a lot of them were employment-based immigration benefits. For example, the H-1B cap registration fee would increase from $10 to $215. This won't occur this year because the 60-day comment period for this proposed rule doesn't end until March 6th of this year, but it is possible that if this rule goes through and is accepted, that the H-1B petition fees could increase this year. And for the I-129, that would be an increase from $460 as the base fee to $780. So overall, it would be like a $320 increase. In addition to that, part of the proposed rule is that USCIS wants to charge an additional $600 fee to fund the asylum program for every I-129 or I-140 petition that's filed. So that would be an additional $600 fee for every H-1B petition that's filed if this goes through. The other change that they have proposed is to premium processing. The fee itself of $2,500 is going to remain the same, but they're proposing to change the timeline for them for taking some action from 15 calendar days to 15 business days. So that would give them, a few more days to take action on cases filed with premium.
Yeah, thank you for that quick summary.
Mm-hmm.
So kind of summarizing that, part two of this H-1B process, where the I-129 petition is submitted, essentially we're looking at about $300 additional coupled, about $900 additional. Basically, that's the asylum fee and the increase in terms of the I-129 fee. So it'd be $900 higher than what you see here on this sheet. So let me talk about the chronology of kind of how these folks may be entering your work stream. We had sent an email to our clients just kind of helping HR folks identify like who actually needs H-1B sponsorship. And this is the most common way. It's not the only way by any means, but it's the most common way that we see folks join a company through H-1B status. So you have somebody who is graduating from a local university, it could be a variety of degrees that they've focused on. And they are typically given a one-year work permit. It's referred to as OPT, or optional practical training. And for those who are graduating in a STEM field, they get an additional 2 years. So that would be 3 cumulative years of work permit time before an H-1B visa is actually necessary. So on the right there, you'll see an employer submits an electronic registration for H-1B. And then if they're in fact selected, they would then submit that I-129 petition. So that's that part two that we were talking about from the time frame of April 1 to June 30th. There would be a receipt notice that is typically issued from immigration agency confirming that the I-129 petition was received. And anyways, that F1 international student graduate can continue to be employed typically until September 30th if, anyways, something called the cap gap regulation applies. I'm not going to kind of go into extensive depth about that right now. Under regular processing, anyways, it's been as short as maybe 3 months. We've seen as high as maybe 7, 8 months in terms of regular. And so this is kind of that cap gap regulation that we were talking about. So what this does is it allows somebody who's got an expiring work permit, let's say it expires sometime after April 1, as long as they were selected within the lottery and an I-129 petition was filed on their behalf, they have continuing and automatic work authorization after that their current EAD expires. Note that there will be some follow-up actions that will be necessary, including coordinating with the International Students Office and confirming that continued work authorization within that I-20. So that's the cap gap regulation. We also deal with H-1B changes of employer. These are instances that don't necessarily fall within the lottery cap process. So this is an instance where, let's say, an H-1B worker wants to transition to Apple, and essentially an employer would submit an I-129 petition on their behalf. There's a slightly different rule here, which allows that new H-1B worker to begin employment with Apple upon a properly filed application with USCIS. And so that serves as a great advantage because you don't have to wait until an approval has been issued. And so, yeah, anyways, you typically don't need premium processing in those sorts of instances. Within those H-1B, like, I guess, transition processes, when you have an employee who is seeking, who already is under H-1B status and wants to join your company, one of the things that you'll want to find out, and this is kind of after the I-9 process and the actual hiring and interviewing process, is how many years of H-1B status have they already utilized. I mentioned earlier that there's a 6-year maximum in terms of H-1B status. And so certainly if you've hired somebody in year 5 and they only have 1 year left, it'd be best to know about that as early as possible. Once again, it's not an appropriate question to ask within an interview or application process.
Regarding preparing and filing H-1B petitions, part of what we're doing ready to file H-1B cap registrations and also for H-1B change of employer petitions that Roger just discussed is sort of reviewing the job position that's being offered, as well as the foreign nationals qualifications, to see if there are any issues that would present sort of complications that we would think would lead to additional scrutiny from USCIS. To qualify as for the position to qualify as an H-1B role, it must require a bachelor's degree at a minimum in a specific field or small number of fields. And the immigrant employee must hold a bachelor's degree in one of those related fields. In addition to that minimum threshold requirement, other things that USCIS routinely looks at and often issues requests for additional evidence on relate to whether or not the role is a specialty occupation, which that is sort of part and parcel of the, does it require a bachelor's degree at a minimum? And do other individuals holding this role with, the petitioner company or other similarly situated companies require a bachelor's degree at a minimum? Another big thing they look at that's more specific to the individual employee is, has that person maintained their immigration status? Meaning, are there any gaps or breaks in status where the person, maybe was an F1 student, but fell out of status because they weren't attending school, or they graduated and they didn't, transition to OPT or CPT with employment in the US quickly enough. So those are things we're looking at. Another thing that has typically been a big issue that USCIS would seize onto issue in RFE would be whether or not the employer has control and supervision over the employee. That issue arises most often when there's a staffing company and they are the H-1B petitioner and they're the employer, but they're placing that employee at a third party location. This is something we see probably most often in maybe some IT contexts or even somewhat within engineering. If there is a middleman and say, for example, the person is placed at one of the major automotive companies. This is a context I've seen this before, whether they're Chrysler or Ford or GM, but they're employed by a more like middle entity. And usually we have to be prepared for that in advance and have sort of documents from the end client confirming that the employer maintains supervision and control over the employee. USCIS looks at is the salary that's offered to the H-1B employee, because it has to meet a certain threshold, which we'll talk about more in a moment. And the Department of Labor has published wage levels for each occupation that are specific to the location that the person is employed in, usually sort of more or less by county. It's a little more complicated than that, but in general. And if the person is paid at the lowest wage level for their area and their occupation, that is something USCIS can look at and use as part of an argument that it is not a specialty occupation. Those sort of RFEs have been less common in the last 2 years. It was something that we were seeing a lot more of in, I would say, 2016, 17 timeframe. Hopefully that will remain the case. The final thing that USCIS is often checking is if the position requires some sort of occupational license, like in the medical context, or maybe even engineering, if it requires a professional engineering license, they're looking to make sure that the individual possesses that licensure to qualify for the role. Okay. As I alluded to, there are salary requirements for H-1B petitions. Essentially, the employer must pay the H-1B employee the higher of the actual wage level paid to other employees in similar roles in the work location, or the prevailing wage set by the Department of Labor for that work location, whichever is higher. This is something we can investigate in advance, for depending on the position and the work location. We have to file a labor condition application as part of the I-129 H-1B filing process. And in that, the employer is attesting that they're paying at least the prevailing wage for the position in the location of the employment. In some instances, a survey, like a third-party survey, can be used, in particular for universities and affiliated nonprofits. They can use prevailing wage calculations for similar institutions. I haven't worked with wage surveys too much. I don't know if you have.
We haven't either. We've traditionally just accepted the U.S. Department of Labor FLC data center prevailing wages. It is possible to seek out a private wage survey and to use that and assert that. You don't get the same, quote, safe harbor that you would from basically using the U.S. Department of Labor numbers, essentially. You may also face greater scrutiny from USCIS in the form of an audit. So.
One other thing I would add to salary considerations is, particularly in light of what's occurred in the last couple of years since the COVID-19 pandemic, which is that now more than ever, employers are allowing employees to work remotely from a home location that's sometimes in another state, or they could have a hybrid working model where they're working part of the time from home and part of the time from an office location. When that occurs, we have to list the employee's home location as well as the employer's office location on the labor condition application. And if the employee is working remotely from an area where wages are much higher for that particular role, that can raise this prevailing wage substantially. Like, for example, if the company is based in Draper, Utah, but the employee is working in Denver, Colorado as a software engineer, the wages of software engineers in Denver, Colorado is likely to be significantly higher than in Draper, Utah. And that prevailing wage for Denver is the one that would control. So it can cause issues. So this is something that I think we've been seeing more and more questions and concerns about in the last couple of years.
Absolutely. And I think a lot of HR folks and employers have been blindsided because immigrant employees have moved to a different location, not often notifying the employer. So anyways, that can certainly create additional wage obligations that you need to be aware of. I want to mention also, a lot of employers are really focused on trying to get that H-1B worker kind of employed and onboarded as quickly as possible. And certainly our team wants to help you with that as well. But as part of employing an immigrant employee under H-1B visa status, there's all sorts of obligations and sort of legal compliance issues that you may not be fully aware of. And in short, they're not always coming up and arising, but they certainly have potential financial obligation and implications. I would note that, like, the failure to comply with labor condition application or H-1B regulations could lead to civil fines up to $35,000 and also debarment from basically applying for future H-1Bs and labor condition applications. So these are just some questions that if you have ever filed an H-1B, you'll want to think through. So are you properly maintaining a public disclosure file? It's also known as a public inspection file. These have to typically be maintained for a 4-year period of time after the H-1B is filed. So anyways, if you don't know what that is, a public disclosure file, a public inspection file, in the later slides, we actually, and this will be sent to you once again, anyways, we have a list of the documents that need to be included in that public disclosure file. Have you filed an H-1B amendment when there's been a material change in the employment, right? So this could be a change in the work site. This could be somebody who's an individual contributor who's now taken direct reports. It could be somebody who's moved from county to, like, from Utah to Texas. Anyways, all of those would be a material change, which would trigger the filing of either a new labor condition application or potentially an H-1B amendment. Are you ensuring maintenance of immigration status for H-1B transfer workers? In light of the current economy, we're seeing immigrant employees who may have lost their jobs, and they may not always be fully forthright about indicating that there has been a break in their employment. I would note that in order to transfer H-1B status, individuals do need to be maintaining lawful immigration status. We'll talk about this a bit further. There is a grace period that is offered for folks who are under H-1B status and terminated a bit early. If you have more than 15% of your workers in H-1B status, there are additional recruitment steps that have to be taken. And so that's something to be aware of. Generally, we have not had employers who have had greater than 15% H-1B employees, so that has not been an issue. Sarah mentioned earlier, if you have independent high-tech contractors who are really your employees that you're controlling on a day-to-day basis, anyways, the immigration agency expects you the H-1B petition. So anyways, you certainly want to watch who has that employer-employee control. Have you had salary cuts that have reduced H-1B workers below the prevailing wage? That can certainly be an issue. Salary, you are required as an employer to pay that labor condition application I-129 petition asserted salary. And anytime you are reducing the salary below that amount, you either have to file an amendment and basically notify the USCIS, or in the alternative, you will be obligated to pay back wages at a later point. When you terminate H-1B workers, are you offering to pay return travel? So anyways, immigration regulations require that whenever you lay off an H-1B worker before the end of their 3-year or shorter time frame of H-1B visa status, that you offer to pay for return travel. 99% of the time in the real world, the immigrant employee will not take you up on that. They want to stay in the United States, and they'll try to find another employer that will sponsor them for H-1B status. You always want to be aware of how many years left each H-1B worker has, not just on their current H-1B visa, but relative to that 6-year maximum that we talked about. In short, we advise employers to initiate that green card process at approximately year 4 out of the 6 years. The green card process can be a long one, typically taking anywhere from, let's say, 2 to 15 years. So anyways, your immigrant employee is certainly very mindful of that process and that time. And anyways, it would be helpful for you to be aware of that as well. For the employers that we work with, we try to regularly remind them on an annual basis to basically kind of move forward with that green card process. Obviously, the choice is theirs. Sarah will kind of talk further in depth about terminations.
Yes, so I think Roger covered some of this, but as an employer of H-1B workers, you have an obligation, if you terminate those individuals, to notify United States Citizenship and Immigration Services and the Department of Labor of that termination. Otherwise, you could risk accruing back wages that could be considered due and owing to that H-1B worker. As Roger mentioned, the other for employers is to offer the reasonable cost of return transportation for that individual to their home country. We usually tell our clients we would strongly recommend doing so in writing, so there's a record that you've made the offer. As Roger said, 99% of H-1B employees will not take the employer up on that return transportation because in general, most of them are looking to find a new employer to sponsor them for an H-1B change of employer petition so that they can remain in the United States. But nonetheless, it's a compliance issue to make sure that you offer that reasonable cost of return transportation. That does not have to be for their dependents either. It's just for the H-1B worker. The other important thing is if you terminate an H-1B employee, they usually have a 60-day grace period from the time that their employment with you ends to basically secure new employment and have another employer file for them so they can attain some other employment authorized status through a new petitioner. The caveat to that is if their validity period in their H-1B that they currently have expires before that 60-day grace period, then that would cut short the 60-day grace period. So for example, if employee X has H-1B validity with you till September 1st, 2023, and they're laid off today, they would have that 60-day grace, the full 60-day grace period, because they have all the way until September of this year. If they were laid off just before that September 1st date, that would cut short their grace period.
The other thing I would just briefly add is if until an employer has completed the step of providing written notice to the immigrant employee, written notice to the immigration agency, and also offered to pay that return travel cost, as an employer, you still retain that obligation to pay that I-129 petition salary. So you're fully on the hook to continue to pay that salary until all those 3 steps have been completed. And then going on to layoffs.
Yeah, so this is a big question lately, especially in light of some of the events that are happening in the U.S. Economy and workforce. So as an employer, if you lay off workers, including H-1B workers, or you're trying to do a reduction in wages, if you lay off an H-1B worker, then you have to follow the same procedures we just discussed for termination, where you offer them reasonable return to travel to their home country and notify United States Citizenship and Services that you separated from them. You can't, as an employer, reduce wages, however, of H-1B workers. You're obligated by filing the I-129 petition with the labor condition application to pay the wage that's offered to them in that labor condition application. So even if you're doing a wage reduction across the board, that wage reduction cannot apply to H-1B workers because you're set with the minimum wage that was offered to them in the petition that was filed. This was a question I got all the time when the pandemic first occurred, as many employers did reduction in wages for April, May, June of 2020. And it was definitely an issue they had to work through in terms of identifying who their H-1B workers were, because those individuals' wages could not be reduced. So then they had to make a decision as to whether or not they were going to fully lay off those people or leave their wages as is, whereas, maybe some of the rest of their workforce had reduced wages.
I'm curious, Sarah, in that instance, I guess, would a possibility be that employer file an amendment, which is costly in itself,
right,
to kind of update the immigration agency on, let's say, a 20% reduction in salary?
That's the other option, is to file the H-1B amendment petition. However, sometimes, depending on what the initial offered wage was, it still has to be above what the Department of Labor sets as the minimum wage for that role in the area of employment. One thing I had some clients do was reduce the hours from 40 hours a week to 20 hours to try and account for that. So there are strategies that can be employed if something like that occurs. And I would encourage people to reach out to, someone who's been through this to sort of walk them through that as it becomes sort of complex if there are reductions in force. The other, as we discussed, reducing hours is something that can also only be accomplished if the employer files an H-1B amendment petition. If the initial petition was filed for full-time employment, 40 hours a week, the employer can't just unilaterally reduce the person's hours to 15 or 20 without notifying the government, because that's considered a material change to their employment.
Great points. Yeah, so bottom line, you're going to bump up against that federally mandated prevailing wage, which is specific to that specific county and that occupation. Great. So this is let's see.
I mean, either of us can talk about it. So permanent residency, this is something that Roger has alluded to at a couple points in this presentation. And it is the essentially employment-based green card process. This is something that if you have H-1B workers, you have to be aware of. And as Roger said, we encourage employers to start this process no later than the 4th year of 6 of someone's H-1B status, because it's a 3-step process and it takes quite a long time to go through the steps. The first step, which is called PERM, is the filing of a labor certification application online with the Department of Labor. It involves a test of the U.S. labor market to be able to demonstrate that there's no qualified and willing U.S. worker who meets the minimum requirements of the role. And if you can get through that step, which takes 12 to 14 months, the next step is filing an I-140 application to the United States Citizenship and Immigration Services. And the third step is the I-485 application for permanent residence or a green card. For many employees, we can file step 2 and step 3, I-140 and I-485 at the same time if their preference category is current. The reason I say preference category is because each year the US government only gives out about 144,000 green cards. And of those, the US government will not award more than 7% to nationals of any one country. As a result of that, countries with nationals who are seeking green cards in far higher numbers, such as India or China, have developed quite a backlog. So when Roger said earlier it could take 15 years to go through this process, that's primarily for nationals of India because there's quite a large backlog. Like right now in January 2023, the priority date, the main one for Indian nationals seeking a green card, is in November of 2011. What that means is that individuals who had an approved I-140 with a priority date before November 1st, 2011 are now getting available green card numbers. So it's about an 11-year wait for them from the time that we complete step 2 to the time that they can file step 3. But it's important nonetheless to go through this process and started around year 4, because for, primarily Indian and Chinese nationals who are subject to these backlogs, having an approved I-140, which is step 2 of this process, allows us to extend their H-1B in 3-year increments beyond the 6-year maximum. And that's vital. And that's something that a lot of employees are monitoring really closely, because that's their ability to, continue living and working in the US.
Great points. Some of you may be wondering in terms of broadly kind of what does it cost to get an employee sort of a green card? Typically double the cost of an H-1B, kind of in the ballpark of 12 to 15,000. That is spread over many years, so it's not a cost that you have to bear in just one single year. Recognized. I would also just mention there's no obligation by an employer, number one, to sponsor anybody for an H-1B visa. It's entirely at your own election. And number 2, you're not mandated or required to sponsor anybody for permanent residency either. We've seen some immigrant employees, as a condition of basically kind of their employment offer, they've wanted to insert clauses as to kind of an employer will start a green card process within a year or 6 months or whatever time frame. So that's becoming a bit more common. Just want to mention kind of what we're seeing in the real world. These are kind of in the light blue color. Essentially, this is kind of the rates of approval that we're seeing just on a market national level. Our firm continues to have great success in terms of H-1Bs, permanent residency processes, I-140 processes. Once again, as you can tell, both Sarah and I and our team take great care with each of these cases and want to do the best by these people. These are goals that we kind of just set out for ourselves. But anyways, what I'm trying to state here is that our goals align with your goals. We recognize that as an employer, you want to get somebody onboarded as quickly as possible. So typically, anyways, we should be able to file an H-1B relatively quickly within a 3 to 4 week time frame. We start every conversation regarding immigration processes with a call. That helps to flesh out kind of more complex and challenging issues, and also get alignment in terms of timeframes and likelihood of success. We're in regular contact with HR departments regarding I-9 questions, regarding stray E-Verify type questions. So obviously, if you have any of those, feel free to reach out to our team. Here's our contact info. and we're at the top of the hour in case you'd like to reach out to either of us. I would mention we will be sending a follow-up email, and it will include a copy of today's presentation. It will also include kind of a fairly extensive frequently asked questions summary regarding the H-1B lottery, and it goes into much greater detail about kind of the nitty-gritty questions that some of the immigrant employees may ask. So that's a helpful resource. We have also attached an H-1B lottery intake questionnaire. And anyways, if you'd like to work with us within the context of the H-1B lottery, you just need to go ahead and complete that questionnaire. We'd ask that you complete that by the end of January 31, so that we can move forward with the timely H-1B lottery registration submission on March 1 to March 17. With that, I'm going to just kind of take some time to respond to any additional questions that we have received. I did see a question. This came, my apologies, a bit earlier within the presentation. The question was whether or not the what do we see or prognosticate in terms of possible numbers in terms of H-1B lottery registrants? Last year, once again, was 480. The year prior was roughly about 308,000. I don't know, Sarah, if you have any opinions. I have some opinions too.
I mean, I think it wouldn't surprise me to see it go down from 400,000 this year, given that some of the big tech companies have been seeing layoffs in the past several months. I would think that given that they would have less submissions than prior years, I think we'll still be well above the 85,000 total. Maybe we'll be back more in the 300,000 range would be, I guess, my educated guess. I don't know if you agree or disagree.
Yeah, I think in that 300,000 to 400,000 range sounds right. So I don't think we'll be as high as last year at 480. I think it'll be a little bit less. What we're seeing also is kind of the effect of no longer being in the Trump administration. There were a slew of technology companies, particularly kind of offshore Indian-based large kind of Infosys, Tata type companies that basically voluntarily agreed to reduce their H-1B registration numbers. This was in the Trump administration, and that, you know, they stopped doing that within the context of the Biden administration. So anyways, I think we'll continue to see high numbers, but probably not as high as last year. So yeah, probably in the high 300s would be my guess. Yeah, and I think in terms of that, the wait list that we talked about, I think, anyways, most likely employers should kind of expect a final answer around March 31 of 2023, in terms of whether or not their candidates were selected within the H-1B lottery. There may be some subsequent selections that may occur, but I think it's very, very unlikely that folks would be then notified and selected within that additional process. Once again, if you've got any questions, feel free to put it in the chat box to the right. We're going to just hold on for maybe another 2 minutes or so just to see if there are any questions. I will mention that we've got some of our paralegal and specialist staff here with us as well. And so I'll let them ask any questions that they may have too, and you can hear their voices.
No pressure.
By the way, I'll just say it's great to see so many of our existing clients join on the call, and it's great to see your names. So we'll wait for another minute or two.
Yes, and if people have questions that they don't necessarily want to ask to the full group, you're welcome to email us too. We're happy to respond that way if you don't want to be put on the spot in this context.
And note that you can ask your questions just to like Roger Tsai rather than all to everyone. Yeah, so. Yes, our internal team, any questions that you guys may have thought of, like anything that didn't make sense?
No, it was all pretty quick.
Sorry, there's a question. You mentioned that for Indian nationals, the green card process will take longer due to application numbers. Is that the same for Mexican nationals, Cecilia?
Similar, but not the same. So there is often a backlog for nationals of Mexico as well, but the backlog wait time isn't as long for employment-based categories. For family-based categories, the wait time may be longer for Mexican nationals, but not for employment. And every year, or I'm sorry, every month, just for everyone's knowledge, the U.S. Department of State publishes something called the Visa Bulletin Report. And that Visa Bulletin Report provides the priority date cutoffs for different employment-based categories, and it's broken out per country. So if the country has a backlog, which is essentially India, China, Mexico, and Vietnam, then those dates will be listed out separately under the country. And then there's a category called all other. So for nationals that aren't from one of those countries, and we're talking about country of birth here, just to be clear, not necessarily country of citizenship. Country of birth is what controls for this backlog and this visa bulletin. For people that are not from one of the countries, they are in that all other category. It would be, subject to probably maybe no wait time or a much shorter wait time because there's less of a backlog.
Great.
That's a good question. Thank you.
Any other questions? The attendees? Great. We'll let you drop off. Enjoy the rest of your afternoon, and thank you for joining us on this webinar. Once again, there'll be a follow-up email. It'll include kind of the SHRM and CLE type information as well, a copy of the PowerPoint. We will be repeating this presentation on February 2nd at noon at the same time. If you have a colleague that you think may benefit from this presentation, a hiring manager, an immigrant employee, feel free to share it with them as well. Thanks and have a great day.